Hi, my name is Robert Chelle with Chelle Law, and my law firm assists physicians with employment contracts issues. Today I'm going to talk about whether no moonlighting clauses are enforceable by the employer. So, when a physician is an employee or even an independent contractor associated with an employer, there will be generally some kind of language that either prohibits or requires some kind of approval from the employer if the physician wants to do what we would call outside activities. So it can be exclusivity is one way of referring to it. Outside activities is another way of referring to it. Moonlighting, locums, that type of thing. I'd say most contracts kind of group it into outside activities. And so in that case, what that would mean is that in the agreement, it would state if the physician wants to work for any other employer when they are providing the practice of medicine, they have to get written approval from the employer in order to do that for a couple of reasons. From the employer side of things, they don't want their employee, the physician, to be engaging in the practice of medicine, which may interfere with their duties for the employer. This is also kind of specialty dependent. So let's say the physician's a hospitalist or works in the ED, 7 on, 7 off. The employer generally doesn't care what they're doing on their week off. So if the physician wants to pick up extra shifts, then usually there's no problem. However, they have to let the employer know that they're going to do that. And then the employer would have to approve in writing that they are allowed to do those things. Most contracts will also state if the physician is going to work outside, so for someone else, they also have to get their own medical malpractice policy that covers their work with that employer. And then most places also want the physician to provide the employer with a copy of that malpractice policy just to make certain that the physician is taking proper safeguards. Now, if you're a physician and you are going to moonlight or do locums or whatever on the side, that employer absolutely would provide, or at least should provide, malpractice insurance for you. And they would be the one to cover the cost of that policy as well. And then you obviously can get a copy of that policy and then provide that to the new employer. Most employers just simply don't have a problem if the physician is going to work outside, like I said before, as long as it doesn't interfere with their duties with that employer. Now, let's say your primary care, and then you want to, on the weekends, work at another primary care office, potentially building up a patient base. Then your current employer certainly may say, we don't want you doing that, because maybe if you leave, there would be anti-competitive behavior by doing that, and maybe you could siphon patients away from our practice. So no, we're not giving you approval. You can't do outside activities. But if maybe you're a surgeon, let's just say you're a pediatric plastic surgeon working for a children's hospital, but you also want to do some general plastic surgery on the side, maybe at a surgery center for a different employer, then usually that type of scenario, the employer wouldn't care that you're doing things on the side. Once again, as long as it doesn't interfere with your general, duties for, your current employer. Now, are these clauses enforceable? Yes, they are. There are some states that will, prohibit / non-compete clauses are completely unenforceable. So I'm not going to go through every state, but California, New Mexico, Massachusetts, these states prohibit the employer from putting a non-compete into the contract. However, that does not generally apply when the person is employed. It only stops having the non-compete, which always takes effect after the contract is terminated. But there will also generally be language that says, while the person's employed and working for us, they cannot compete, with our employers. Or the easiest way to do it is for them just to say, you have to get written approval if you're going to do any practice of medicine anywhere else while you're employed with us. And that way, there's really no ambiguity about it. The employer then has complete control over the situation. So if you're a physician and you have every plan to do locums, moonlighting, whatever you want to do while you are employed, and there's a clause in there that says, either this is your one and only exclusive job. If you want to do anything else, you have to get our approval. They absolutely can be enforced. They just can. So you need to, in advance of signing the employment agreement, if you have either a current job that you would like to continue, or maybe potentially you have a job in mind that you'd like to pick up while employed, I find going through that prior to signing the employment agreement is the best way to go. So many of the contracts will have an exhibit at the end, which then lists all of the outside activities that are pre-approved by the employer. So I certainly would state that the physician should do that. They need to disclose. So what happens if you don't disclose outside employment? Well, you're in breach of contract. So if you sign an agreement with some kind of outside activities clause, and then you start doing outside activities without getting approval, you are in breach of contract, and they could potentially terminate the contract because of that. They can generally terminate it immediately in that type of situation, or maybe they would just state, this is what your contract says. You can't be doing these activities. We're not going to terminate you. However, we are going to say to you, you need to stop those activities right now. So that's, is moonlighting, or at least a clause that states the physician can't moonlight enforceable? Yes. But generally, there's some ways working with the employer that would allow the physician to do that. If you have any questions, you can always call my law firm at the phone number listed below in the description, or you can always reach us through our website, ChelleLaw.com, CHELLE law.com. And appreciate you watching the video, and take care.